All right, everyone. So we've been talking about non-immigrant visas, immigrant petitions, and then Laura just talked about consular processing. You've gotten the foreign nationals over there to come here, and now you need to make sure that you're prepared for enforcement responsibilities, obligations that you have because you sponsored the foreign national. What we're going to do, Matthew Webster is joining me today, and we're really pleased to have Matthew join us, our team. He's our newest attorney, but he has years of experience prior to joining us in employment and labor. So it's a great complement to our immigration practice to have that perspective, especially in our enforcement practice, and so we're really glad to have Matthew join us. So we're going to talk today about enforcement priorities and trends, preparing for I-9 audit, immigration audit files, what I just mentioned, the obligations that employers have when they hire foreign nationals and file H-1B petitions or sponsor labor certification green card applications as part of the PERM audit file obligations, and talk about how you can create a worksite investigation plan. Part of this new trend or the current environment that we're facing is about buy American, hire American. And so what that means is the enforcement priorities of this current administration is to make sure that U.S. employers are hiring U.S. workers, and anyone that they are hiring is authorized to work in the United States. So it's not just border security and interior enforcement in terms of individuals who are unauthorized to work, but it's also looking at employers and making sure that they're employing individuals who are authorized to work in the U.S. And it also means that those who file non-immigrant petitions are not engaging in activities that may discriminate against U.S. workers, and the attestations that you are making when you file H-1B petitions or L petitions or green card perm labor certification applications are accurate and you're complying with it. So what we've seen in terms of this enforcement environment today is definitely statements from ICE, Immigration and Custom Enforcement, that it is hiring more ICE agents not to only focus on arrests of undocumented individuals in the U.S., but also to increase the number of I-9 audits. The director of ICE stated that it intends to quadruple the number of I-9 audits in the U.S., and that is why employers, I feel like we're colluding with each other when we're talking in this type of environment, in that we want to make sure that you are prepared for these worksite visits and your I-9s are in good order, your audit files are in good order, because there's just no reason. You can be proactive about it, and that's what we hope to start the conversation with you today on. So, Matthew, you're going to talk about I-9 forms, right?
Yes.
Which is not only for foreign nationals, it's for all employees.
Yeah, and that's something a little unique about this specific presentation, is that this obviously affects all of your employees. As Lon said, I come from an employment and compliance background, and so I've worked a lot with employers over the years, and these forms seem so innocuous, and they always come in the midst of recruitment and excitement and filling out benefits information, and there's a lot of other things on the employee's mind and on HR's mind. But these innocuous documents, it's just a 2-page document, as you know, have a lot of potential pitfalls, and they have this extremely long half-life, right? The retention period is 3 years from the date of hire or 1 year after the employee's left. And most of the I-9 violations are continuing violations. So we'll talk about that, but these aren't just kind of simple mistakes that are innocuous. They can have a really long half-life if there's an audit. So there are sanctions attached to I-9 violations. Again, these are simple 2-page forms, but they can come with some hefty sanctions ranging from $110 to over $1,000 for kind of simple substantive violations. But your more egregious and knowingly hiring an undocumented individual can range from $375 to $16,000. So these have large consequences, obviously, for organizations, and those sanctions are per error, per issue. And so a single I-9 form can have upwards of 6 to 8 issues, right? If you fail to date, if you fail to include the correct documentation, if you fail to completely fill it out, they can have multiple violations per form. So we'll kind of breeze through this, but we've also provided a lot of materials that you'll be receiving after today's presentation, most of them relating to the I-9 compliance. We have a fast fact sheet for you that will go into a little more depth on these, the I-9 compliance, and then kind of what to do for audit and preparedness within the workplace. So in terms of the first section, this is the section for the employee to fill out. And some things that come up with this, obviously it needs to be completed in a timely fashion, which can be any time after the offer of employment, before that first date of employment. One thing that you want to make sure you're not doing is pre-populating this section. This section is solely for the employee, so you don't want to be involved at all in that. That's different than sections 2 and 3 in which the employer is filling those out. We'll also talk a little bit more about kind of setting up triggers for yourself or ticklers for when documents expire, but this is kind of the first area where you would find out that somebody might have a document that might be expiring in the future. You'll also come across it again when you actually check the document in section 2. But we'll talk about that in terms of ensuring compliance. On section 2, again, this is for the employer, and this is to be completed within 3 business days after the individual starts employment for hire or for pay. You cannot require specific forms of documentation. And what I mean by that is you can't require that individuals show you a green card or show you specific forms within the allowable forms. In terms of the allowable forms, this has been improved with the new form I-9. You want to make sure you're using the current form. It's the only one that's accepted now. But the nice thing about it is it does have a pull-down menu, and so there's less kind of checking the M274, the big manual, right? There's like a 96-page manual for a 2-page form.
But it's our best friend.
But it is our best friend. The nice thing, you can always go back to that. You can always call us. But the nice thing is, too, there is a drop-down menu for the acceptable forms. So again, any of those forms can be accepted. And you just want to make sure if you have a one from list 1, that's all you need. If you have one from list 2 and 3, you need one of each. And sometimes employers think that, you know, if one list 1 document is good, what about 2? Isn't that even better? And this is kind of a common thing. You know, oftentimes an employee will come in with a whole folder, right? They come in with really prepared, they have all their documentation, and they just show it all to you. You need to be sure that you're not over documenting, because that's also an independent violation. You only want to include what is necessary. So if somebody has a list 1 document and they present 3 of them, you only include 1 on section 2. So again, the employee is going to be really proud. They brought all their documents. Again, they're really excited. They want to hear about the benefits that you're going to talk about after filling out the Form I-9, but just make sure that you're aware of that and including only the documentation required. In terms of section 3, this is again for the employer, and here I think the main thing is just make sure that you have some sort of docketing system for re-verification. So if somebody has a document that expires, you want to make sure that you put that into some system, a tickler system that will send you an email or some spreadsheet that you check on a weekly basis or a monthly basis to make sure that you're re-verifying individuals' employment authorization before those documents expire. So re-verification is required if somebody's employment authorization expires and needs to be re-verified. If the employee is hired within the retention period, when they come back, you need to re-verify. And then if they have a name change, those are kind of the triggers for re-verification. The one that you would need kind of a system for would be a document where the individual is still working for you, they've been working with you for a long time, but their document has expired. You need some sort of inner mechanism for doing that. As Lon said, we're seeing an increase in audits and expect more to be coming, and that kind of puts more onus on you as the employers to make sure that your documents are in order. And so we really highly encourage setting up a regular internal audit. either an annual or semi-annual basis, but make sure you are regularly auditing your own files. They allow you time to review and not be in that time crunch. When you have an audit take place, you've got 3 days to respond. And if you've never looked at these documents, if they just kind of went into the black box underneath and you're pulling these out for the first time, there's going to be a lot of work to do to make sure that they're in order to present. And even just finding them, if you haven't looked at them in years, might be difficult. So make sure that you're regularly revisiting them. It can reduce the number of violations. As I said, some of these are continuing violations, but some you can change and correct and kind of start a statute of limitations. So it can decrease your potential risk and your potential liability. I think another big thing is it allows you to intervene early. So if you have somebody who is consistently making over-documentation mistakes, for example, and you have a regular audit in place, that might only occur for a couple employees. You can do some retraining, make sure that the I-9s are being filled out appropriately, and then stem that from happening for years and years. If you aren't doing those, you're not going to catch those until your government audit comes. It also allows you to identify potentially questionable or fraudulent documents if you're revisiting those documents. And then we also encourage partnering with legal counsel. One key benefit of this allows the attorney-client privilege to cover some discussions and kind of privileges that audit process.
So the next section of our presentation is really a practical look at what happens during an I-9 audit or investigation by ICE, Immigration and Customs Enforcement. And Matthew mentioned that we do have materials that you're going to be sent electronically. One is our I-9 Fast Facts to really provide an overview of the Form I-9 and provide some do's and don'ts. But let's talk about what actually happens at a ICE inspection here in case you do get that notice of inspection letter. That is the first step. When ICE issues a notice of inspection letter, it means that it wants to review your I-9s, and you have 3 business days to provide copies of all of your I-9s and supporting documents. If you make photocopies of supporting documents as part of your I-9 process, you should make sure you provide those supporting documents along with the I-9s. If you are an E-Verified user, you should also include that in the requested information. And this is really critical because what happens is as we go through the I-9 inspection process. So the first step is you provide the requested information in response to a notice of inspection along with any other documents that have been subpoenaed as part of that notice of inspection, okay? Hopefully you call counsel right away when you get that notice of inspection. And ICE will have those documents for a while. The next step is that if there are questionable documents in your I-9s, meaning if there are I-9s where they believe some of your employees have provided fraudulent documents, they will issue a notice of suspect documents. If there are documents that they just don't know if they established employment eligibility or not, then there is the document of that is issued called the Notice of Discrepancies. So this stage of the I-9 audit is really critical for employers because this is where it hurts the most. The I-9 process in terms of, the fines can be hurtful to an employer, but in our experience, after many years of assisting employers with I-9 audits, it's the loss of your workforce that is most harmful. We've seen I-9 audits result in a loss of workforce, 80% of the workforce, or 50%. And that is why this is so concerning right now, because we know that the focus is to remove individuals who are not documented in the United States. And we know that the focus will be on worksite enforcement here. It's been clearly communicated. We're just waiting for it to substantially increase. So once an employer gets a notice of suspect document, they have to respond to the notice of suspect documents and provide new documentation if documentation is available to establish employment eligibility. Then after you go through the process of knowing whether you lose your workforce or some of your employees or not, what happens is that you'll get a notice of substantive violations. And the Immigration Customs Enforcement Homeland Security investigation will give you 10 days to make corrections if they are substantive violations. What it allows for you to do in the 10 days is to make corrections where they become technical violations. And ICE usually does not fine in those situations if you have technical violations, but substantive violations is where you'll be facing the fines. So if you make copies of supporting documents, you can often make corrections which will turn a mistake into a technical violation instead of a substantive violation. So I'm a proponent of making photocopies. Years ago, prior to 2008, perhaps not, because that was what we normally advise, that you don't want to make copies of supporting documents because they can be proof that the documents were fraudulent and you did not take good faith steps to look at the documents. And so practitioners would advise their clients not to make copies of supporting documents. But under this administration, and since 2008, when the Obama administration really increased I-9 audits, we've never had a situation where an employer was fined because they lost 80% of their workforce, but didn't have any substantive violations because they kept their I-9s in order, or they were able to correct them and with supporting documents. We've seen fines, though, when there have been substantive violations and the employer was not able to correct the I-9s. So that's one of the steps that is listed there, the substantive violations. And then you wait and see if you get a warning notice, which is just you made some violations, but we're not going to fine you for it, or you'll get a notice of intent to fine, which will list out all your violations and the fines that you will face. So what happened recently in 2017, in January of 2017, was ICE increased the fines related to I-9 violations. For example, it used to be $110 per violation, and now it has increased to $220. This is for a first-time violation. And the way that ICE will fine you is not, Matthew talked about how you can have multiple violations in an I-9, but our experience in this jurisdiction and what we've heard in other jurisdictions is that they will only fine you per I-9 and not per violation. So that's what you should be aware of, and the potential exposure that you may have if you have I-9s that are not filled out completely or with mistakes or untimely. It will be per I-9 that you will be fined. Let's hope they don't change that. So pretty much that's the overview of the I-9 audit process by the Immigration Service. We're going to talk about site visits very quickly because we've already talked about FDNS in terms of the increase in site visits. In your materials, we provided for you what to expect and how to prepare for government worksite visits. This is all going to be sent to you electronically. If you're not the appointed person responsible for this, if it does happen at your place of employment, share it with that person. It's really important that you be prepared. And so, we also provided for you guidance on establishing a corporate immigration compliance plan too, which talks about what should be in your compliance plan. And if I had to give one recommendation only to employers as to how they can maintain a compliance program that will help protect them, it would be to appoint one person in your organization who is responsible for responding to worksite investigation requests. If a law enforcement officer comes on site, who is that person who is responsible for communicating with the law enforcement officer, the immigration enforcement officer? You don't want your legal assistant or your as secretary or the receptionist to be on the front line of this, but they need to be informed of what they need to do and who is the person they need to contact if you have such a visit. In our materials, there are other recommendations, but if I had to provide one, that is one that I would have an extensive conversation with you about, because it's critical. What happens when ICE or Department of Labor comes to your work site? You don't want them to be meeting with the wrong individual or talking to individuals who are not familiar with your immigration process or procedures. And so that's really important to be prepared for. And our materials lay it all out. We have a really robust compliance program that we share with our clients, and I'm really happy to share these materials with you. We talked about FDINS, but Department of Labor worksites, when the wage and hour division comes to you or Department of Labor to look at your public access folders or to determine whether you're complying with your wage requirement, they do not have to issue a letter. They can just show up and start interviewing people. You need to know that. And in your materials is a Know Your Rights card that we've provided for you too, as to what your rights are as an employer. So make sure that you take a look at it, because I know it's very, it's scary when law enforcement or, someone from the government contacts you, but I think it's really important to know that you do have rights as an employer, and your employees have rights too. What we're seeing an increase in is ICE visiting work sites to issue a outstanding order of removal or outstanding warrant of removal, and employers get really scared and they think, okay, I have to get this employee and have them speak to ICE, and that's just not the situation. You need to be prepared for that in this current environment as to what rights your employees have, and inform them of that too. So best practices to ensure compliance, again, with non-immigrant petitions or H1B filings. We do a lot of H2s also. We haven't really talked about that today. There's just a increase in wage and hour investigation for these type of applications. So make sure that any applications where you're required to maintain an audit file, that you have the correct information. If there's any change in employment for H1B situations, you need to inform the Immigration Service of that, file a new LCA. It's just making sure that you know what's going on if you're responsible for the immigration filings and responsibilities within your organization, and comply with the document retention requirements of each of those practices. So H1B compliance, we talked about LCA and public access folder. Just know that you have to maintain the public access folder for at least 1 year after the end date of the validity period of the H1B petition, or 1 year after the termination of employment. That's the public access folder. Anyone can come in to ask, to request to look at that folder. It's not just the Department of Labor or wage and hour investigation. Also, the PERM audit files, which is for green card sponsorship, you need to maintain it for 5 years from the date of certification. We work really closely with you to provide you with these folders, but we don't have it after we give it to you, especially the H1B folders. So you need to make sure you update those folders, specifically the H1B. The PERM audit, there's really nothing to do, but the H1B, you have to update if there's any wage changes, changes in employment benefits. Make sure you look at those annually to make sure they're updated. in regards to wage and hour, it's about maintaining earning records. What is the hour offered? What are they being paid? That's what wage and hour is really looking at. Are you treating U.S. workers the same way as foreign national workers and vice versa? And that brings us to protecting U.S. workers. And Matthew, do you want to discuss the Immigrant and Employee Rights section of the Department of Justice, which is a new name for what was previously the Office of Special Counsel?
Yeah, and I think that name is significant of the change, right? It used to be Special Counsel for Immigration-Related Unfair Employment Practices, so really aimed at the immigrants, protecting immigrants, and now it's the immigrant and employee rights, so kind of co-equal, and that's really borne out by the cases that they're bringing. I did just a sampling yesterday of kind of the recent cases, and it's fairly evenly split between protecting immigrants and protecting employees. And some examples of those are a preference for H-2A workers in nursery and forestry positions. So those are some of the cases that they're bringing. Again, protecting U.S. workers from an employer's perceived preference. These are settlements, so they weren't fully adjudicated, but allegedly, the employer had preferences for H-2A workers over and against U.S. citizen workers. Another one that just came out was a Korean restaurant in New York City having preference for foreign nationals from Korea and Japan to serve as waitstaff and serve as employees at this Korean restaurant over and against U.S. citizen workers. So again, this is in the Department of Justice. It is a division that has long been at work, but its mission is somewhat different now under the current administration, and so we're going to see more of these kind of coming up. And again, the focus is on protecting U.S. workers. H2, H2A, H2B could come up in perm cases, kind of tests of the labor market. As part of the permanent residence process, you have to show that there are no other available employees, and so kind of testing that could be part of this DOJ section's initiative.
And it's really ironic because this entity was established to protect discrimination against national origin, non-citizens. And it's really interesting to see this change. And it's not only under this current administration, it really actually started under the prior administration where the focus was really to look at how U.S. workers are also being harmed in terms of employment practices and everything. So this office has really evolved in regards to that. And so we are going to end this presentation on Worksite Investigation Response Plan because we want every one of you to have this, which is to have this knowledge of know your rights, the card I mentioned, know what your rights are as an employer, what your rights as your employees also have. I had a situation where an employer called me and said, I have ICE here, they want to speak with this employee, what should I do? And I said, we went through this. Remember, we established a plan, and it's scary. You can't think of it right away when someone comes up, but they did have a plan that we have put together, which was, and I just had to remind them, remember, they have to show you who they are. Are they indeed ICE? Are they indeed the Department of Labor? You can't take it for granted that they're who they are. And if they want to see your employee, you have the right to say, I will inform the employee, or let me call my counsel. You do not have to present your employee right away and have them face this individual. This is your place of employment. This is your establishment. And so it's really important to know what your rights are.
So as part of this kind of worksite response plan, here in Minnesota, we do kind of fire escape plans and practice those. We do tornado drills. It might be useful to do kind of a mock one. Again, just with the people who would be facing it, probably your frontline staff, your receptionist, your secretary. Again, they're probably not going to be the people designated to be the individuals talking, but they need to at least know who to call. So again, you don't necessarily need to do a dry run, but they do need to know exactly who to call, who to bring in, and what to do, because it's never a convenient time and it's never a planned for time when these audits occur.
Yeah, and also make sure that the right individuals in your company are informed of the investigation. It's amazing how something may happen, but the CFO or the COO may not know about it, and then they get contacted a couple of days later regarding official documents that are needed. So just make sure you inform key company officials that have been designated to be privy